good evening, folks. We are going to go over just the key aspects of closing arguments before we do our second run-through of closing arguments tonight. The number one rule is you need to be efficient and focused. And me telling you that just doesn't seem to accomplish that with new lawyers, because based on the new lawyers that I see, this is a very difficult lesson to learn. But the key is to be efficient and focused, and to have the confidence. Really, it's about confidence. The confidence that the jurors will understand, that the jurors will get it, and that you don't have to hammer away at the same points over and over and over again. That they have the intellectual firepower, all 12 of them, or however many of them there are, to understand what it is you're getting at. It's not effective to summarize or repeat testimony. It's not effective to go through witness by witness accounts of the trial. They've seen it after all, and they didn't have this incredibly nerve-wracking experience. They sat there and were relatively calm and were able to watch it in a pretty leisurely way. So they know what happened, except for the longest trials, like a trial that's 6 months long, which are so incredibly rare. They know what happened and they remember it, and they don't need to be hammered over the head with witness by witness accounts of what happened. What you're really doing is you're speaking to a few undecided jurors, and you're arming the people that you've got on your side for the deliberations. You're arming them with the important points, with the powerful points. And so you have to teach them and lead the jurors in achieving justice and fairness. Last time you gave a series of wonderful closing arguments, but let's take it to the next level. So this time, focus on things like justice and fairness and emotion. These are critical parts of the decision making by jurors, and they are critical parts of the decision making by even judges. Obviously judges are a lot more disciplined about it, but judges and jurors and people, it's really about emotion. And if you don't hit that, if you don't appeal to the emotional aspects of your case, some people call it the equities, then you're giving up an important battleground. You're ceding an important battleground in almost any case. Almost any case. So you're going to get to the core issues really quickly, and you have to be really candid and acknowledge what you're weak at, and just give up what you must give up. The best thing you can do is to say, they've got a good point about this, and to explain how the other side is right about that one issue. That's the best thing you can do. That establishes credibility with the jurors. They're much more likely to listen to you. If you battle on every issue in a closing argument or in any part of the trial, that's the path to losing your case. That's really a huge mistake. So you have to persuade them through your content and your delivery. So the goals of the closing argument, you've got to be quick and efficient, really quick and efficient. It's really, I say that, but it's so hard for new lawyers to get that. And you have to use themes and labels. Themes, powerful, sophisticated themes if possible, and the right labels. Labels that humanize your side. So your client is always James Smith, and the other side is always the defendant or that corporation. That's what I mean by the kinds of labels. You've got to use labels that remind the jury, almost subliminally, that your client is a real live, breathing human being, and the other side is a faceless monolith. And it's got to be about emotion. It's got to be about emotion, and it's got to be quick and focused and efficient. So the modern beginning, or what I call the modern beginning, but what Professor Maue calls the impact beginning, you've got to use a modern beginning. None of the, and I don't believe any of you did, probably because I said it to you 10 times, and I apologize for that. for not understanding that you would get it in your collective wisdom. But, so the modern beginning is not about a civics lesson. This is where, ladies and gentlemen, I'll talk to you about the facts, but the judge will instruct you of the law. No civics lessons. That is, that's from the Jurassic period. We don't do that anymore. And there are a variety of ways of making a modern beginning. And you can be hammering away at your theme, hopefully a good one if you're going to use it at your beginning. You can just immediately insert the jurors in the event, especially if it's a very emotional event. Or you can use dramatic evidence from the case. Maybe it's not the actual event, but maybe there's dramatic evidence. And there can be, I think at least one of you, I challenge you today to talk about your client's background. Not so much at the beginning, but there can be, and there often is, really powerful evidence in a case about a party's background and life experiences. And some of that is arguably irrelevant. It's one of these unwritten evidence rules. But some of it, the judge is always going to let you get in. And so what if the judge keeps some of it out? Big deal. You're not there to make friends with a pompous judge. That's not your purpose in life. You're there to do your job, and it's not your job to be popular with the judge. So, one way or another, hopefully in an ethical way, you get in evidence of your client's background. This can be powerful stuff. And it can be the beginning of a closing argument. And you can draw reasonable inferences from evidence about your client's background from which you can weave a much bigger picture. You've got to have, in that beginning, in some fashion, there's got to be emotion. There's got to be emotion, or if you have to, you can use some, probably not the right term by me, but you can use some hokey but inspiring story. I'm going to suggest to you that's not the best route, but it's an appropriate one if you've got nothing better. So if you have a closed case, you've got to argue both sides. So you just can't argue your side. You've got to respond to the other side's arguments. On the other hand, if you were meant to win this case and it's not, you really were meant to win this case and that you have an overwhelming case, then the social scientists recommend not giving giving short shrift to the other side's arguments. You should argue the emotional core of the case, and in most cases, you should answer the questions as best you can imagine them that the jurors might have about your argument. So much of it is about delivery. You've got to be, you don't have to be, but it's much better if you're bold and assertive. But if you're new to it, or if you have a style that, or if you adopt an unconventional style, your lack of being bolder and assertive, it's got to be clear to the jury in one fashion or another that your what we call it, your nervousness, your timidity is from inexperience or something else. Not because you have any lack of belief in your client. Now you can't express your belief in your client, but there are ways of communicating to the jury that you believe in your client. You don't have to be smooth. There's no problem at all with being a total klutz in the way you talk and present yourself. It is not a big deal. You can be 10 times worse than George W. Bush, 10 times worse than Mayor Menino in the way you talk. It's not a big deal. Nobody cares. But the apparent sincerity of your belief in your client, you can never say I believe in my client, that's an ethical violation. But your apparent sincerity that your client deserves to win, that is justice, it better be really clear or you're in big trouble. So when you make your points, be assertive and confident. If you possibly can, back up your points. You basically always have to use the exhibits. Now, this is a course in trial advocacy at this great law school, and it's a simulation, but there are some limitations. But if you're going to do a closing argument, with one tiny exception, if you're going to do a closing argument, you've got to use the exhibits, demonstrative aids, whatever you've got. So at this very early in the course set of closing arguments, we don't really very much put that kind of demand on you that you use demonstrative aids. But in a real trial, you better use those demonstrative aids and exhibits. There's one exception that I can think of, and that is there's a species of criminal cases where the defendant is really in deep, deep trouble, where the defendant really has no evidence and is really in terrible trouble in terms of any objective measurement of the evidence. And all of the exhibits are from the prosecution. And the only evidence for the defendant comes from cross-examination of the prosecution witnesses. It is conceivable in a case like that that you might not refer to or actually use the exhibits in the case, because after all, they hurt you really badly. But in that kind of case, does occur. You should always refer to the jury instructions. We're doing kind of mini closing arguments here, but in a truly complete closing argument, you should always be making some reference to the jury instructions. I'm not saying that you should go on about the law, because you shouldn't. But you should be orienting the jurors to where they should land in the jury instructions, in the key pivot points, and where they should land on what I'll call the jury questions. The questions that the jury answers, the verdict slip, which can be anywhere from 1 to 50 pages, depending on the nature of the case. So you should quickly, efficiently tell them where you want them to go on those documents. The jury instructions are slowly trending towards being actual documents given to the jurors as well. Very slowly, but they are definitely trending that way. You should always be talking about common sense and life experiences, and forget about being intellectual, forget about being graduate students. So you've done a wonderful job of learning this whole new language and way of thinking, really, and that's really important. You've done a wonderful job of that, and now it's time to grow out of that and to get rid of that and to talk like a regular person. And that's why, so we use common sense, we use experience of life. That's the mantra of jurors and is often in standard jury instructions. Stories and analogies are fine too. Argue stories and analogies about what your grandmother told you. Now, you may have heard, I believe a couple of classes ago, someone may have said something to the effect, didn't somebody tell me that you don't really object during closing arguments? We're going at this from the perspective that this is a super intense, high stakes case. In a criminal case, a murder case, or in a civil case, a wrongful death case. And unless people are lawyers are kind of wrong-headed, not realizing what they're dealing with there, you object if it's good strategy and well-based. You object when it's time to object. You don't, if it's good strategy, if it helps your client. There are no rules like, it's closing argument, I have to wait until the end of the closing argument. I'm not going to digress much about that, but you object when you need to object. And one thing you got to watch out with stories and analogies is there can be some objectionable talk in stories and analogies if you start to talk about us or we, or as you know, when you were growing up, your grandmother would tell you, you got to be careful about putting the jurors in the place of a party or a witness. Rhetorical questions, of course, are great. Always use rhetorical questions. That way, your lack of the jurors will not be offended by your attempt to preach to them. You should and try to avoid any kind of a lawyerisms that you possibly can. You've seen my naughty words list, I hope. All of those words are absolutely forbidden, and I'll keel over in cardiac arrest if you use any of those words. No civics lessons. So the ending of a closing argument, you've got to show, you've got to plan out your ending, really. It is possible to, and there are a variety of ways of preparing these closing arguments, and pretty much all of them are fine. At this early stage in your career, and maybe for a very, very short time, you need to do the closing arguments without notes, in my opinion, and I've explained this in detail. And that maybe you'll be able to do closing arguments before you leave law school without with notes. That's fine, I get no problem with that. But how you get to that point of being able to give a closing argument without notes, that's up to you. And there are a lot of different ways to do that. And a lot of them do not involve planning out exactly what you're going to say. A lot of them involve really working from kind of a list of words, maybe, that jog your memory about what you want to talk about, kind of topics that just fire neurons in the back of your head, enabling you to make that argument. But the closing of your closing, the end of your closing, needs to be planned out word for word, basically, in my opinion. So the end of your closing, you need to end on an emotional high point, and you need to show passion, emotion, and then your result is justice. And so that's something that's demanding. That's asking a lot. So that has to be planned out, and I recommend you plan pretty much word for word your closing to your closing. You also want to hit on that same theme. Everybody needs to hit more on the theme. So let's say you do a 10 or 11 minute closing argument. The theme usually is either at the beginning or very close to the beginning, probably 3 to 5 times during the closing in the body of it, and then again at the end. And much more mention of the theme is totally legitimate. But that's how big a theme is to a high-end closing argument. And it's one of the very few ways that I disagree with some of the things that Judge Saylor said in his excellent book, because I agree wholeheartedly with 99.9% of what he says. But one of the things, and it's hidden away in a little paragraph somewhere, one of the things he basically says, he doesn't really say it this way, is you can drive people crazy with your theme. I respectfully disagree. And you should orient the jurors again to where you want them to land on that verdict. So different jurisdictions call different things, but the jury questions, the form that they check the boxes on and sign. So so you should remind them very quickly, depending on the complexity of the case. In civil cases, the verdict slips can be 50 pages long. But in a pretty simple case, you want to very quickly tell them what you want them to do in the verdict slip at the end of your closing. So your delivery, you should, obviously, you should avoid legalese and any pompous legal police language or any of the naughty words. Please avoid those things. And you should, your body movement, it's something to get used to. And I think you folks are amazingly good at it, actually. But it's about controlled movement. So we don't want to do what I judge these high school mock trial competitions, and all the time, they're incredible because I only judge the finals, semifinals, so these are the best teams. And some of them will give a 20-minute closing argument. By the way, think twice before you go beyond 20 minutes. A 20-minute closing argument like this, I mean, it's actually kind of a good workout, but it really is scary for someone who's watching. And don't wear a pad in front of the jury box. These are all things I did during my career. You know, none of this. It's about controlled movement. And it isn't necessary that every movement be I don't agree with the rule that never talk when you're moving. I'm going to recommend a little bit more free form than that. But some folks think you should never be talking when you're moving. You should never be talking when you've got your back to the jurors or hopefully the fact finder if that can physically be done. But very controlled movement, moving for a purpose, having given it some thought. And that's what I'm trying to do. Now all I do is sit up on the bench all day long, and I am not the best at delivering a closing argument or a lecture. Try to avoid nervous movement. Make a reasonable amount of eye contact with each juror during the case. But don't scare them by making too much eye contact. And never hit the bar as a rhetorical device. Never touch that, or whatever that piece of furniture is called. So there are problems in closings. All right, so and closings can be extremely boring because lawyers haven't figured out haven't put their minds inside of the jurors' minds. You know, on some level, the jurors are not really interested in listening to you. The closing arguments, they've heard it all. They do not think you're smarter than them. You know, so you've got to cut away 80% of the stuff you want to say. You can't bore them. It's so easy to bore them. And we hear, judges, we hear so often about how the lawyer, you know, the big joke, if you want to get a big laugh when you're talking to jurors after a trial, which you won't be able to do without the judge's permission, you say to them, and this is not funny, but it always gets a big laugh, if they'll ask you a question in the jury room afterwards, and you say, well, I'd like a sidebar conference on that. And they all crack up laughing. The reason they all crack up laughing is because you've driven them crazy with all those sidebar conferences during the trial, the 150 of them that you had. And that they really, on some level, detest the lawyers that have put them through this experience, and they don't want to hear from you any more than absolutely necessary. They want you, on some level, to sit down and shut up. A weak first minute. You got to grab them with that modern opening, the modern beginning to your closing argument. You got to grab them. You got to grab them. I'm looking hard for that. That's the way to do it, not the way they do it on the book website. You know, may it please the court. Oh my gosh. Lack of full use of themes. Everybody, you all got to be hammering away at those themes, and you got to use the right labels. At least some, at this level, some by your use of the right labels, it tells me that you understand what I'm trying to communicate about labels. And hammering the themes over and over again. Don't summarize the evidence. This is about argument. Too much law and insufficient passion. These are the weaknesses in closing arguments. But I know you're all going to be amazing because I've seen you do it once. Thank you.